Good morning, this is your Kelso Report for Friday, September 7th. I'm your host, Clark Kelso. In today's cases, we review the requirement of misrepresentation in a securities fraud action, the question of whether SSI benefits should be counted as income for purposes of determining a litigant's ability to pay for attorney's fees in a juvenile court matter, whether mere acquiescence is a sufficient basis for triggering the agreed boundaries doctrine to settle a property line dispute, and the proper interpretation of Section 471 of the Penal Code. We begin with securities fraud and misrepresentation. In order to state a claim for securities fraud under Section 10b of the Securities Exchange Act of 1934 and SEC Rule 10b-5, a plaintiff must allege a material misrepresentation or omission by the defendant, scienter, a connection between the misrepresentation and the purchase or sale of a security, reliance upon the misrepresentation, economic loss, and loss causation. In In re Rigel Pharmaceuticals, the plaintiffs complained about certain statements made by a drug company's officers concerning the results of a clinical drug trial which, according to the plaintiffs, overstated the efficacy and safety of the drug. The district court had dismissed the complaint, concluding that the plaintiff had failed sufficiently to plead misrepresentation or omission. The Ninth Circuit affirmed the dismissal. It was apparent that the allegations of falsity were actually nothing more than a complaint that the defendant should have used a different statistical methodology in performing the drug test. There was no allegation that the defendants had inaccurately reported the results of their own statistical analysis. Instead, plaintiffs simply challenged defendants' reported statistical results by alleging the defendants should have used plaintiffs' chosen statistical methodology. For the Ninth Circuit, those allegations did not rise to a material misrepresentation. As the court explained, plaintiffs' allegations of falsity essentially are disagreements with the statistical methodology adopted by the doctors and scientists who designed and conducted the study. The allegations are not about false statements. Complaint was dismissed. Our next case involves juvenile court and how do you know whether a plaintiff has the ability to pay for an attorney. In our legal system, certain litigants who are too poor to afford legal counsel will have counsel provided for them. In criminal cases, this right to counsel is of course constitutionally based, ever since the Supreme Court's famous Gideon decision. Well, in California, we have extended the right to counsel to juvenile dependency proceedings as a matter of state statutes. Under our state statutes, a parent, however, remains liable for costs to the county for legal services rendered by an attorney appointed by a juvenile court to represent the parent and the minor in the dependency proceeding. But the amount of that liability ultimately depends on a parent's ability to pay for such legal services. A key question in determining ability to pay is how much income the parent makes. In re SM, the Superior Court treated both Social Security benefits and supplemental security income benefits for disability as income to the parent. The Fourth District disagreed and reversed. It agreed that Social Security benefits should be treated as income because they are intended to replace lost earned income after a person reaches retirement age. But supplemental security income benefits are not intended to replace lost income. Instead, they are made available when an applicant has suffered a qualifying disability, and the payments are designed to defray the increased costs of treatment associated with the disability and to maintain a minimum decent standard of living. Accordingly, since SSI benefits are not intended to replace lost earned income, the Superior Court should not have considered those benefits in determining the parent's ability to pay. Next, we have a boundary dispute between two neighbors. When neighbors disagree about the location of the boundary between their properties, how is that issue to be resolved? Well, the first thing that probably comes to mind is to check with the appropriate local government offices to see if there is a definitive map showing the boundaries, or maybe there's a deed somewhere establishing the boundaries. The next thought probably is to bring out an expert surveyor to try to mark the boundary. Well, sometimes neighbors decide to just take matters into their own hands, dispense with the time and expense of the experts, and simply agree on where the boundary is located. In California, the courts have endorsed an agreed boundaries doctrine, by which title can be established by virtue of an agreement between neighbors. The requirements of proof necessary to establish a title by agreed boundary are well settled. The doctrine requires that there be first, uncertainty as to the true boundary line, second, an agreement between the coterminous owners fixing the line, and third, acceptance and acquiescence in the line that's been so fixed for a period equal to the statute of limitations, or under such circumstances that substantial loss would be caused by a change of its position. In Martin v. Van Bergen, the Second District had to resolve whether the elements of the agreed boundaries doctrine were met when, several decades earlier, predecessor property owners had replaced an old cattle fence that had long existed with a deer fence between the properties. In reliance on the placement of that fence, one of the property owners had planted an almond orchard. However, the evidence established that these predecessor owners never really questioned whether the fence was placed correctly on the property line. They had no dispute about the property line. They thought the cattle fence was the property line, and therefore they had no reason to enter into a specific agreement about where the property line was located. At most, it was fair to say that both parties silently acquiesced in the belief that the fence indicated the property line. Well, fast forward to the present, and when a couple of surveyors examined the property, it turned out that about 10% of the orchard was actually on the other neighbor's property. According to the Second District, the agreed boundaries doctrine did not apply because there was evidence only of acquiescence and not of actual agreement to the fence line as the boundary. In reaching this conclusion, the court emphasized that the agreed boundaries doctrine should be construed strictly and should apply only when its elements are clearly met, because the true and actual boundaries are generally to be preferred to boundaries set by other informal means or methods, such as an agreement between the parties. Finally, we have a statutory interpretation case. The dominant method of statutory interpretation in California is the so-called plain meaning rule. Now, as we all know, under the plain meaning rule, if a statute has an unambiguous meaning, it is given an interpretation consistent with that unambiguous plain meaning. A great example of this approach can be seen in People v. Dunbar, where the defendant was charged with some 24 felony counts of forgery under Section 471 of the Penal Code. The defendant was the controller for a private company who, over the course of 5 years, managed to steal almost $7 million by regularly shorting the business on checks received from customers. His scheme consisted of depositing the full amount of the check in his own private banking account and then writing a check from that account for a lesser sum to the business's account. He would then modify the bank deposit slip so it would incorrectly show the full amount of the customer's check, and he would then enter into the company's books that full amount. Well, as soon as he left the company and a new controller was appointed, the scheme was discovered and he was arrested. The trial court, however, dismissed all of the charges that were based on falsifying the company's records. According to the trial court, Section 471 applied only to falsification of public records, and did not apply to forgery of a private company's records. The 4th District disagreed and reversed. Section 471 provides that, quote, every person who, with intent to defraud another, makes, forges, or alters any entry in any book of records, or any instrument purporting to be any record or return, is guilty of forgery, close quote. Well, as the 4th District explained, the statute does not limit the term book of records in any fashion at all. Instead, it broadly refers to any such book. And the courts give the word any its natural, broad interpretation. Since Section 471 does not have any language indicating that it should be limited only to public records, the trial court was wrong to give the section that limiting interpretation. The plain meaning controls. And that's it for today's Kelso Report. Have a great day in the law and a good weekend.